So to go back to my proposition, I made the comment that I really struggle with the idea of inserting anything into the Constitution that provides special benefits to any individual grouping of Australians. To be fair, we need to ask the question, Marcia Langton has said that the Constitution is a racist document. What would be the basis of that claim? Because I've always thought of it as a dry and dusty document that is not racist, despite making a couple of modest provisions for the looking after by the Commonwealth, making laws by the Commonwealth for Aboriginal people. On what basis might it be seen as a racist document?
Yeah. I mean, it's partly a complex question, but in another sense there's a simple answer to it. I think on the face of the document it's not racist because it doesn't, on the whole, draw distinctions between people on the basis of race and accord special rights to some because of their race or place special detriments on people because of their race. It doesn't work that way. It presupposes that we all are citizens and that we're equal citizens, and therefore we all have an equal opportunity to be involved in politics and become members of Parliament, or nominate for election to Parliament or voting in elections and all of those things. So in that sense, I don't think it is at all racist. In that sense, as people sometimes say, it's colourblind. There is the race's power. So there's a power to make laws for the people of any particular race. But the High Court has come very close to deciding, hasn't actually finally decided, that can only be used for the benefit of Indigenous people or the people of any particular race. I mean, it could be argued that even having that clause in the Constitution is inappropriate because it's not quite consistent with the concept of common citizenship. Yeah,
it's my position that we ought to have a look at those things again and strip them out and explicitly say this is completely colourblind.
That's right.
Completely. Totally.
So there's another provision in the Constitution that says that in situations where people of a particular race are excluded from voting, they aren't counted for working out the populations of the different states when working out some of the more mechanical decisions that have to be made about representation and the referendum process under Section 128. And that seems racist in a sense, but actually what it does is it creates an incentive not to exclude people from voting. Because if the state of New South Wales was to exclude the people of a particular race from voting, then its numbers would be reduced by that amount, and therefore its representation in the Parliament would be reduced by that amount, which would weaken its voice in the federal Parliament. And so even though that on its face looks like it has a racial sort, and it is racial, it has that incentive effect of undermining racially discriminatory laws when it comes to by the states. Yeah. Now
maybe that could be cleaned up now too.
I think that could definitely be cleaned up. Yeah, and I think it should be because I don't think it's necessary, and I don't think in principle it's a good thing for the Constitution to be drawing distinctions on the basis of race. And the High Court's been very clear about this and increasingly clear about it, that the Constitution is premised on an idea about universal citizenship for all Australians, without distinctions on the basis of sex or race, for example.
To move on a little from this then, there are countries that have established treaties, as we know, particularly Canada and New Zealand. There's a couple of questions that arise out of that. Firstly, to observe that in the case of New Zealand, you had a much more recognisable form of government. The treaty that was signed there was not actually with all of the people of New Zealand. That's often overlooked. And it was only possible after the missionaries had set up schools right across New Zealand and a language emerged, an understanding of language and writing emerged, so that you can actually write out a constitution, a treaty. So there are particular circumstances that did not pertain here. That needs to be remembered. It's not an argument against the treaty so much as to say, try and understand why there wasn't one struck initially. There were very good reasons why it couldn't be done, even if they look unfortunate now in the context of the times. And we need to be careful about judging those who went before us. But more generally, what constitutional arrangements have been put in place in Canada? Well, firstly, has it amounted to a drift towards co-governance? And secondly, how's it been allowed for constitutionally in those two countries?
I think you'd have to ask some specialists about those sorts of questions. I'm not on top of that in a lot of detail. But I think it does tend to move towards co-governance because it provides foundation upon which Indigenous peoples have, in the terms of the treaty or the implications of the treaty, establishedly, they're recognised as such, as governing partners in government. And in fact, some of the Australian reports have proposed that the voice itself would involve a sort of model of co-governance in a certain sort of sense of the word, when the subject matter of government policy was the Indigenous affairs in some way or another. What's actually interesting is I've argued that one of the reasons why New Zealand never joined the Australian Federation was that treaty, because when the Australian colonies were looking at federating, New Zealand was really a real possible party to that.
Well, they participated in one of the earlier constitutional conventions.
That's right. And a lot of people say, oh, well, it was distance, but Perth was just as far away from the eastern seaboard as Auckland was. And one of the things that it really occurs to me when you look really closely at the debates is that New Zealand had actually developed more rapidly than the Australian colonies, because it wasn't just the significance of the treaty wasn't just that the Indigenous or the Maori entered the treaty, but was that the New Zealand government itself, through the Crown, was able to itself enter into a treaty. None of the Australian colonies had ever entered into any treaties either. They weren't able to do it. So it sort of was about the maturity or immaturity of both the colonies as well as the place of the Indigenous people that sort of shapes these sorts of things, which underscores the extent to which we have to understand our constitution in evolutionary terms. In the sense, we've got to understand that the constitution evolves very gradually on the basis of the principles that are already established within it. And that creates, as I've said too many times probably to you, a certain path dependency of the steps that you take then have knock-on effects going forward. So, I mean, I would even go so far as to say that where the voice is inserted into the Constitution will make a difference. Because if it's put into a chapter on its own, it structurally gives it a significance that it wouldn't otherwise have. Because at the moment, we have another institution called the Interstate Commission, referred to in section 101 of the Constitution, but not in its own chapter. And in quite emphatic terms, there's meant to be an Interstate Commission. Doesn't exist, has existed, but it's not in its own chapter. Because when you look at the chapters of the Constitution, they reflect the important institutions of the Constitution. That's why Chapter 1 is about the Parliament, Chapter 2 is about the executive government, and Chapter 3 is about the courts. And then we have a separate chapter about the states, because they are the four important institutions, as it were. And so when you put an institution into its own chapter, you're elevating it to a status that's similar to those other institutions, even if its functions are different. So, in one sense, going back to a comment you made earlier, would the voice be a third chamber of the Parliament? No, I don't think it would be a third chamber in the strict sense of the word.
That was Malcolm Turnbull.
Malcolm Turnbull said that. Yeah, that's right. And I don't think it would be a third chamber in the strict sense of the word, because you have the two houses of Parliament that have to legislate, and the voice is not given legislative power per se. What it's given, though, is an authority to make representations, and that has its own special dynamic. It's a unique capacity, but it's a capacity, and it's capacity different to making laws. It's a capacity different to executing the laws. It's a capacity different to what judges do when they decide disputes, but it still is a function in and of itself that's very significant, that's designed to, if it's approved by the people, shape legislation and shape executive government policy insofar as it relates to Indigenous peoples. So I think that's the best way to try to understand it. And it will be significant if it's proposed that it goes into its own chapter as opposed to a section on its own, because the structure of the Constitution is also part of its meaning. And the High Court has said that.